Good afternoon, my name is Huq. I teach in the law school. I teach constitutional law and a number of other classes. I've been asked to speak to some of the legal aspects of the debate over the Innocence of Muslims video, in particular in relation to calls for the prohibition or the ban of the video itself, or for criminal penalties to be applied to Mr. Nakula, the gentleman allegedly responsible for the video's creation. I'm going to start off by talking about the international and comparative law context, but the body of my remarks are focused upon US law, and in particular the regulation of speech of this kind under the First Amendment of the US Constitution. And I'll close, once I talk about the US law, with some comments about the normative case, both pro and contra prohibitions and penalties in relation to this kind of speech. Now, before talking about the law, it's worth noting that there are a couple of different ways of framing the basic problem raised by speech of this kind. The first way would focus upon the way in which the video depicts religious identity, the way in which it depicts a group defined by an immutable or normatively taken to be immutable characteristic like religion, and portrays that group in a negative light. So you might think of this as a problem of what's been called group libel. So that's one way of thinking about the problem with the video. The other way of thinking about what's at stake here, and this is somewhat consistent with some of Professor Sell's remarks, is the reason for criticizing and penalizing the video is the departure in the video from standard, canonical ways in which a figure in a religious tradition is portrayed. Call this the blasphemy problem. Now, many of the public calls for prescription or penalties attached to in relation to the Innocence of Muslims video have conflated these two problems. They conflate the argument that the video should be penalized because, or prohibited, because it insults Muslims, a group of currently existing people, with the problem or the allegation that it constitutes a blasphemy. It's inconsistent and derogatory of a religion, a body of thought, an ideology, whatever you want to call it. This is certainly true of arguments made by Presidents Morsi and Hadi of Egypt and Yemen, respectively, in the United Nations a week ago. And perhaps this confusion ought not to be surprising. Group libel and blasphemy raise overlapping problems. Under what circumstances should the state be able to impose a penalty, not on the basis of an infringement of some physical interest, but on the basis of stigmatic, psychological, or relational harms caused by durable speech? Blasphemy, unlike group libel, also raises the question of whether and under what circumstances the state should be in a position to decide what is and what is not consistent with canonical religious doctrine. So I want to focus upon the group libel, group defamation problem. I'm probably going to switch between those two terms, because I think it's the more interesting problem as far as the law goes. And the bottom line is pretty straightforward. Group libel is invalid, or a group libel law would be invalid under First Amendment doctrine in the United States as it obtains today. It would be not only prohibited, not only permitted, but arguably mandated under international law and the law of many other states as it exists today. The US, that is an outlier in an important regard. With respect to blasphemy, I'll just say that under current US law, I think that there is very little question that a blasphemy law would be prohibited, although blasphemy laws are, as has been mentioned, on the books in many other countries in the world. Okay, so why don't we start with what's the case internationally and then go to the US case. So, in the domestic law of many other countries, many other Western liberal democracies even, it is a crime to engage in group libel. And this is true quite beyond the specific prescriptions upon Holocaust denial that Professor Strauss mentioned. So, for example, it's illegal to insult certain groups in France. The Portuguese law focuses upon the defamation of groups. Danish law talks about the degradation of groups and applies a criminal penalty to that. In Switzerland, it's illegal to demean certain groups, even with what the law calls a gesture. It's not clear to me what that means. But Canada punishes anybody who willfully promotes hatred of certain groups. And the United Kingdom outlaws insulting words or behavior that outlaw religious or racial, that arouse religious or racial hatred. Now, all of these countries' prescriptions are not only consistent with, but hew to a command that's contained in international human rights law. Article 22 of the International Covenant on Civil and Political Rights requires that advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. The United States, by the way, has signed that treaty, the ICCPR, but subject to reservations that mean we don't need to carry forward with any of the prescriptions in that, or the requirements of that treaty that are inconsistent with our constitutional tradition. Now, what I've just said implies a uniformity of practice across Western liberal democracies. And I think that that's somewhat misleading. If you start to look at the cases that are actually brought under these laws, there's a good deal of variance, even among European countries, not putting aside countries like Egypt or Pakistan, where the cases of what are arguably misuse of the laws are much more clear. So, for example, the UK recently prosecuted a man for having a placard in his window that said, "Islam out of the UK." Now, this is basically the party platform for Geert Wilders' party in the Netherlands, right? In Turkey, calls for Sharia law are punished, right? That's not the case, for example, in the UK. In thinking about these criminal penalties imposed upon group libel in other countries, it is important to remember that the actual form that the prescription takes on the ground is not just a function of what the rules say, it's a function of what prosecutors think, how independent prosecutors are from prevailing political forces, including the interests of important religious majorities or minorities, the level of judicial independence, and the attitudes of the judges towards norms of free speech or religious difference. Right? So global uniformity, right? So the notion that there's some sort of uniform global practice is at one level true, but that level is pretty superficial. And once you pierce beyond the surface of laws, there's a good deal of variety underneath it. Okay, so how does the US stack up in comparison to the rest of the world? I've already said it's an outlier, but what I want to do is to undermine that conventional wisdom a little bit. And let me start off with two examples from the city of Chicago. So in 1924, the Auditorium Theatre here in the city purchased for show D.W. Griffith's movie, Birth of the Nation. It sold tickets for $2, which at the time was an unprecedented sum. Now, in the audience on the first showing of Birth of the Nation, which I realize I should explain, contains none too flattering portraits of African Americans. I think that's an understatement. In the audience in that first showing of Birth of the Nation was Police Captain Charles Larkin, along with Municipal Judge John Rooney. In the middle of the performance, they stood up, ordered the theatre operator to be arrested, and confiscated the film room. the judge said, and I quote, "It was a great picture, but I do think it would hurt reasonable men and women to see it. It might incite them to hurt others." Okay, so that's one example. Second example involves a gentleman called Joseph Beauharnais, who was president of the White Circle League, arrested on a street corner in downtown Chicago on January 7, 1950, for distributing leaflets that called upon the mayor and the aldermen of Chicago to, quote, "halt the further encroachment, harassment, and invasion of the white people by the Negro," end quote. Beauharnais was charged with violating an Illinois law that made it illegal to distribute any publication that exposes the citizens of any race, color, creed, or religion to contempt, derision, or obloquy. The jury, clearly understanding the meaning of the word obloquy, convicted him and fined him $200. The Illinois Supreme Court affirmed his conviction, and in a 5-4 decision, the US Supreme Court also affirmed his conviction. The majority opinion by Justice Felix Frankfurter held that libel was a kind of speech that traditionally had fallen outside the boundaries of the First Amendment. It was an alien kind of speech to constitutional protection, and therefore Beauharnais' conviction could stand. Okay, what does this tell us? It tells us that the idea that the criminalization of group libel is impossible under our Constitution is a relatively recent idea. Right? It certainly was not true in the 1950s, as Beauharnais' litigation shows us. Even, again, to turn briefly back to blasphemy, even blasphemy has a surprisingly long tradition in the United States. This may have been mentioned before. There are blasphemy prosecutions all the way up to the 1860s, and one can look at certain treatments of the federal government's approach to the Mormon Church as reflecting judgments about the content of the Mormon Creed. Free speech law as a whole, though, is itself a product of the late 20th century. Right? The First Amendment may have been ratified in 1791, but the Supreme Court only invalidated the law under the First Amendment in 1931, right? 140 years after the amendment was ratified. That was a case called Stromberg v. California. And the courts only began to develop a set of rules, legal doctrine, that operationalized the vague, majestic, and ultimately indeterminate words of the First Amendment in the 1940s and 50s, at the time that Beauharnais was decided, and then went on to scrap those rules at the end of the 50s and 60s, and then set up another set of rules. And I think the reason why it is conventional wisdom and accurate to say that group libel cannot be criminalized in the United States is not that Beauharnais has ever formally been overruled by the Supreme Court. The Supreme Court has never said that Beauharnais was wrongly decided. Rather, it's because the new rules for the First Amendment that grew up in the 60s and then in the 70s are inconsistent, fundamentally inconsistent with Beauharnais. Just to give you some sense of why that is, let me give you a before and then an after snapshot. So 1 year after the Beauharnais case was decided, the Supreme Court handed down an opinion called Dennis versus the United States. In Dennis, the court upheld the conviction of leaders of the United States Communist Party under a statute called the Smith Act. The court applied a balancing test. Does the gravity of the evil at issue, here the spectre of global communism, discounted by its probability, justify the invasion of free speech that the law achieves? Applying that ad hoc balancing test, the court in Dennis said yes. In doing so, it put a fairly heavy thumb on the scales in favor of the government. Right? So Dennis and Beauharnais are the old regime. Well, the court has moved away from that sort of ad hoc balancing, that sort of judgment on the basis of its rough gestalt impressions of the particular problems concerned that a law raises. And it's done so, I think, for three reasons. First, it's concerned that if it judges laws on the basis of whatever cases come before it, the government's ability to determine the stream of factual scenarios with which the courts are presented will lead to a body of law that is pro-state. Right? So if you look at, for example, the law of the Fourth Amendment today, that's pretty much what's happened. Second, the court was worried that judges, no less than any other public official, are vulnerable to the political and moral panics of the day. So they need intellectual tools to lock themselves in. Ad hoc balancing just doesn't do it. And then third, there was a shift from the 50s and 60s onwards away from balancing toward a more categorical approach to judicial decision making. And this has to do with other broader trends like the rise of a more conservative judiciary, the idea of originalism as an approach to constitutional law, which are not relevant here. But it's the other, I think, trend that's underlying this shift. And so after Dennis and Beauharnais, there are three cases that are decided in the 60s and then in the 90s that I think provide the guidance or provide binding precedent or valid precedent today that is inconsistent with the criminalization of group libel. So the first of these is a 1964 case, a very famous case called New York Times versus Sullivan, in which the court said libel is not outside the domain of free speech protection. Right, this was an effort by Southern officials to seek money damages from the New York Times based upon its reporting of the civil rights movement. Right? The court is being motivated here in part by its concern for racial politics, but in the process it brings libel in from the cold. So the doctrinal predicate for Beauharnais, the idea that libel is beyond the First Amendment pale, is no longer quite holds after 1964. The second case that is, I think, in tension with Beauharnais is a case called Brandenburg. And this is a case that's famous for lawyers because it installs a rule that protects political speech, particularly political speech that the government perceives as revolutionary, as conducing to danger or violence. And Brandenburg says, look, you can't criminalize speech unless it is actually intended to cause imminent lawless action, and in fact is likely to do so. And so the court applies this very protective test, this very rigid test. In Brandenburg, which involves a KKK leader, there's a number of other cases involving student protests, in a way that's very protective of speech. And then in the third case comes from the 1990s, and it's called RAV versus St. Paul, the city of St. Paul. And it involves a local criminal ordinance that prohibits the display of a symbol that, quote, arouses anger, alarm, or resentment in others on the basis of race, creed, color, religion, or gender. This is it's a hate crimes law. The underlying facts in RAV involved a juvenile, hence the initials RAV, whose idea of fun on a Saturday night was to put up a cross in the front yard of a local African-American family and burn it. Thank heavens for Facebook. Better things to do on a Friday night. So he gets prosecuted, and the court invalidates, strikes down the St. Paul ordinance. And what it says is that this is an ordinance that singles out speech on the basis of its content. It says that certain kinds of violent speech, that which is aimed to arouse anger against protected minorities, is impermissible. And we are uncomfortable with line drawing of that So any law that singles out speech because it protects minorities is suspect after RAV versus St. Paul. Okay, so what's justifying these results? What underwrites the idea that the state should not be allowed to criminalize group libel? Well, I think that the most important argument, and it's an argument that we can see most clearly at work in a case like RAV, is the idea that when the state regulates speech, as indeed it must, for example, think about laws that regulate the use of mobile loudspeakers in residential neighborhoods. Surely the state can say, you're not allowed to drive down the street blaring music out of a loudspeaker at 2 in the morning. When the state regulates speech, it must do so in a content-neutral way. That is, the state must not be in the position of deciding what ideas are correct or not. Right? And this idea of content neutrality is, you can think of as representing or reflecting diverse philosophical justifications for the protection of speech as a core human liberty. There's an idea that transient politicians shouldn't be able to entrench themselves by banning certain kinds of speech. They shouldn't be able to entrench certain policies by banning criticism of those policies. There's the idea that speech, however hateful to others, is a form of individual self-realization. Right? In that sense, it is a crucial part of human agency that must be protected whatever the costs. That's another possible justification for the rule. The third justification is the idea that there are large epistemic benefits from a regime of content neutrality. We benefit collectively if the state cannot tell us what the truth is. We benefit through the democratic process. We also benefit through a free market of ideas. The other justification that this rule finds is the idea that we ought not to have a regime that provides a fairly robust doctrinal framework for guiding judges and limiting their discretion when it comes to speech-infringing laws, so that under the transient political and moral pressures of the day, judges will not buckle under the stress of, say, post-9/11 panic or what have you. And content neutrality-based rules provide a relatively straightforward, simple test that's operationalized through something called strict scrutiny that is arguably achieves that goal. Right? There's cases where the court fails, but it arguably furthers the goal of tying judges' hands to make sure that they really do protect speech. One idea that the protection or the goal of content neutrality is not based upon is the notion that certain speech doesn't harm. Right? The court has never taken the view that speech is harmless. So, for example, there was a case recently involving the Westboro Baptist Church, which is a congregation that protests at funerals of returning soldiers. The form of their protest is, to say the least, extremely hurtful to the soldiers' families. The court in the Snyder v. Phelps case, which rejected a tort action against Fred Phelps in the Westboro Baptist Church, starts off by saying, this is incredibly hurtful speech. No one doubts that speech inflicts great pain. No one doubts that speech has tremendous power that clearly can be harnessed for good or for ill. Another case in which the court recognizes, or a court recognizes, the harms from speech, and says that's we're not going to try balancing these harms either one way or another, is a case from Chicago, American Booksellers Association v. Hudnut, where Judge Easterbrook, who teaches at the law school, struck down Indianapolis's anti-pornography ordinance. Okay. So the idea that speech is harmful is not denied by the court. It doesn't disappear from the doctrine. But the court is not in the business of weighing harms. Right? This is part of the hands tie. So that's the US tradition. What's the case against the position taken in the US? And let me try and be pretty brief. So the first point to make is that the US tradition itself is not entirely consistent. There are areas of the law where something like a rule of group libel applies. So think here of sexual harassment law, right? So you're all familiar with it in one way, shape, or form. But sexual harassment law is basically a legal regime that penalizes certain kinds of speech based upon the fact that that speech harms a particular identified minority. Right? Sexual harassment law is thought to be consistent with the First Amendment. There are also other peculiar lacuna in the First Amendment. A relatively innocuous example is securities regulation. Federal securities regulation says that you can't engage in any speech about a security that you're issuing, a stock or a bond, within a certain time period before or after that bond gets issued. Right? Speech, which, by the way, would be very profitable to engage in. Nobody thinks that that kind of speech is not, which, by the way, is picked out on the basis of its content, as well as its time and place. Nobody thinks that kind of speech is a First Amendment problem. Moreover, in discrete cases, the court, I think, can fairly be criticized for failing to apply its content neutrality rule in a robust way. So there was recently a decision called Humanitarian Law Project versus Holder, in which the court upheld the application of what are called the material support laws to charities' effort to provide aid to communities where designated terrorist groups operate. Right? The court in that case gave very short thrift to what's supposed to be a fairly robust framework. There are also, I think, reasons for resisting the US approach that we can draw from the experience of other countries. So one thing that the European approach tells us is that group libel laws can be very effective at preventing escalating harms to the dignity of vulnerable minorities, right? Whereas the other groups who are subject to harm through speech under a regime of the kind that the First Amendment installs, people like politicians, the state itself, are relatively capable of responding to, resisting that speech. They're relatively tough. That's not necessarily going to be true of the kind of minorities that the group libel laws protect. There's an excellent treatment of this issue, the idea that the purpose of group libel laws is to protect human dignity, by a legal philosopher called Jeremy Waldron. Moreover, the European experience might lead us to believe that the adoption of group libel laws isn't the first step on a slippery slope that leads inevitably to the state imposing its content-based discriminations on the general population. We see that Europeans have been relatively successful in cabining the application of group libel laws to circumstances where the case for those laws is the strongest. And I think the prescriptions in Germany and France on Holocaust denial, the prescription of the Nazi Party and its successors in Germany, you can't form a National Socialist Party in Germany, are evidence of the potential success of this kind of law. It shows that it is possible to single out a particularly harmful form of speech and to extirpate that kind of speech from the public sphere. So there's a case both for and against group libel laws. The US position is not the only one a reasonable person can take. My own judgment is what one thinks of group libel laws is importantly a function of what one thinks about the government that is applying, that is exercising the group libel law. And in thinking about this talk, one thought that struck me was that those instances in which a group libel law is most needed are going to be those instances in which we can least trust a government to use that law wisely. That is, when a government is reasonably trustworthy, is already pre-committed to norms of tolerance, non-discrimination and equality, we can assume, or we can predict that it will use other resources, government counter-speech, the application of anti-discrimination laws, the use of penalties on race-based hate crimes, right? It's a host of things that government can do. Speeches of the kind that Obama and others have engaged in. When a government is committed to tolerance and equality in the first instance, it has many tools other than group libel laws to protect the dignity of vulnerable minorities. And yet, it's in that case that we might think that group libel laws are not going to be abused. By contrast, when you have a government that is weak, that is not committed to equality, that is not committed to tolerance, right? That's the case in which group libel laws are going to be most important, are going to be potentially most efficacious, and yet they're going to be most vulnerable to abuse. So I think that those who say that there is one clear right answer to the debate that the Innocence of Muslims video instigated, I think are mistaken. I think that there are reasonable positions on both sides of the debate.